you were unable to speak for yourself, do you know who would make medical decisions for you? Through what is known as a medical power of attorney, you can specify who you want your medical decision maker to be in case of a situation where you cannot make your own decisions. So this is the person who makes tough choices on your behalf regarding your health care. It's literally, who do you trust with your life? What a lot of people do not realize, though, is that if you have not completed a medical power of attorney, then the state of Texas determines who that person is. Your spouse is first in line, and then your reasonably available adult children. In third place are your parents. If you have none of these, then medical decisions would then pass to your nearest living relative. Let's discuss the first two, your spouse and your reasonably available adult children. Regarding your spouse, all that matters in this context is who is your spouse, who is your legal spouse, even if you're separated. If you do not have a valid medical power of attorney and you are still legally married, your estranged spouse calls the shots. Do you really want your estranged spouse making life and death decisions for you? Maybe you do, but maybe you don't. The second tier of decision makers is your reasonably available adult children. What does reasonably available actually mean? Perhaps you live in Houston and your daughter lives in a suburb of Houston, and say your son lives in Michigan. Most likely, it would be your daughter who is at the hospital, which would be making her the most available surrogate decision maker. In this situation, if you do not want your daughter making decisions for you, then you should complete a medical power of attorney, naming your son or someone other than your daughter, or being clear that your son and daughter are to make joint and unanimous decisions as to your care. What about the age of your adult children? This is something serious to consider. Texas Right to Life has fielded multiple calls that follow this basic fact situation. You have a divorced 50-something-year-old parent who suffered a traumatic brain injury or a severe cardiac event. Following state law, that makes the 18-year-old son or daughter the person responsible for making life and death decisions for that parent. Do you think your 18-year-old child, no matter how wonderful and bright they are, that they are equipped to wrangle with physicians, to advocate for you, gather information, assess your recovery and your current situation? Have you even had a conversation with your 18-year-old about what treatments you would or would not want and in what circumstances? If any of this sounds similar to your situation and there is someone in your life whom you would rather appoint as your decision maker, maybe it's your brother, maybe it's one of your parents, maybe someone completely different, you need to complete a medical power of attorney. To secure a medical power of attorney, speak with an attorney. Usually, medical powers of attorney are offered as part of basic estate planning documents, such as a will. If you do not know an attorney, then Texas Right to Life would be more than happy to connect you with one in your area who shares your pro-life values. Thinking through these worst-case scenarios ahead of time can really be the greatest blessing to your family and may literally save your life. We hope that you have found this video instructive, and as always, Texas Right to Life's patient advocacy team is here to help you. Visit TexasRightToLife.com for additional resources, and please share this video with your friends and family. Thank you for watching, and we will see you guys next time.